Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors. I have recorded a video on the mid-year changes that the Georgia Association of Realtors, or GAR, has made to their contract package. I recorded the video and it turned into, the video was a little bit too long for one video. So I have divided it into two separate videos, and I invite you to please watch both videos. The first video on the 2022 changes that the Georgia Association of Realtors made to the contract package includes information as to where you can find those changes in the contract forms, where you can find a list of what those are, changes to the seller brokerage agreement, changes to the mutual termination of a buyer or seller brokerage agreement, the mid-year changes that GAR made to the purchase and sale agreement, as well as the instructions to the closing attorney regarding agent commission. Part 2 of the video, or the second video, of the 2022 changes that GAR, Georgia Association of Realtors, made in May of 2022. They actually released those changes May 1st. Includes changes that they made to the FHA and VA loan contingency exhibits, changes they made to the documents regarding a closing attorney as the holder of earnest money, the F510, which is the exhibit that goes with the contract, and the F511, which is the agreement that the closing attorney actually signs. Changes, mid-year changes to the residential lease, two brand new special stipulations, as well as changes, a lot of changes, not a lot, but substantial changes to the buyer brokerage agreement. And if you stay tuned to the very end of part 2 of the changes, I have a bonus special stipulation for you. So thank you guys so much for watching. I do appreciate your time. And please make sure to watch both videos, part 1 and part 2 of the 2022 changes, mid-year changes to the Georgia Association of Realtors contract package. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education. Now, another big change you guys are going to want to be aware of in the instructions to closing attorney. This is the GAR Form 255, instructions to closing attorney, that outline the commission that all the commissions being paid by the public to the brokers, and that the brokers are sharing with one another, as well as any commission rebates that a broker is giving back to a buyer or a seller. So that's the form. You guys know what I'm talking about. There is a brand new subsection. So there's a section 3, which is general. That has been there. They've added a new subparagraph C to that general section of the commission instructions. And it reads, the closing attorney is directed to show the above referenced commissions on the settlement statement and to collect the same, in other words, collect those commissions as identified and signed by the brokers / affiliated licensees as a precondition to the parties closing on the purchase and sale of real property, so long as the same is permitted by the buyer's mortgage lender, if any. Moving on, under the FHA and VA loan contingency forms. FHA loan contingency exhibit is F407, and VA loan contingency exhibit is F410. There has been a lot of questions and issues regarding the amendatory clause, which is, and I've done several videos on this, that in essence is the appraisal contingency for an FHA insured loan and a VA insured loan. And in essence, when there is a government insured loan, the amendatory clause is a federal regulation, and it supersedes any special stipulation. In other words, these buyers, I've done thorough videos on this, so please check out the videos and put in a mandatory clause, and you'll see some more information about that. But Bottom line is, regardless of any special stipulation in the purchase and sale agreement. In other words, if a buyer puts in an appraisal gap stipulation in a purchase and sale agreement stating something to the effect of they agree to pay X amount of dollars over low appraisal should the property appraise low. If the buyer is getting an FHA insured loan or a VA insured loan, that stipulation is not enforceable. So it doesn't matter if it's in a contract or not, it is not enforceable. If a buyer is getting an FHA insured loan or a VA insured loan, the property appraises for less than sale price, the buyer may terminate through day of closing and they will get their earnest money back. So that is true of the amendatory clause. It is a federal regulation regardless of any contract between two parties. GAR to help, they've already put verbiage to that effect in the purchase and sale agreement, and on the financing contingency exhibits themselves, FHA and VA, under the amendatory clause paragraph, for further clarification, they have added the sentence that states, the amendatory clause shall apply even when the financing contingency period has terminated. Again, and I've done videos on this too, an appraisal contingency is a completely separate contingency than a financing contingency. Nevertheless, to avoid confusion among brokers, among agents, among buyers and sellers, they've added this sentence for clarification that does state, as I just said, the amendatory clause shall apply even when the financing contingency period has terminated. That's in FHA and VA. Under the GAR F10, which is the closing attorney acting as holder of earnest money exhibit, they have in the section where it's rights and duties of the closing attorney acting as the holder, they have added language where it talks about the closing attorney, let me find that, cannot deduct fees from the earnest money. Now, let me read you what it says. It says, closing attorney shall not have the right to deduct any of the attorney's costs or fees pertaining to the closing from the earnest money or other trust funds being held by the closing attorney. Don't get that confused. Those are fees pertaining to a closing attorney acting as a closing attorney. Do not get confused. And this verbiage is also in the GAR F511. Do not get confused. If a closing attorney has to interplead the funds into a court, in other words, contract fails to close, buyer and seller either don't sign a termination, buyer and seller don't sign a termination and a release, they don't agree on the release of the earnest money. If the closing attorney chooses to interplead it into a court, if it is a loan, if the buyer's getting financing, if there's a institutional mortgage lender involved, or if it's a cash deal and the closing attorney is obligated to interplead it into the courts, there are court costs and fees associated with that interpleader action. Those fees and costs do come out of the earnest money. So that's not what this sentence means. So for fees associated with an interpleader action over earnest money, those do come out of the earnest money that does get awarded to the winner of that lawsuit. What this is talking about is a closing attorney cannot take their fees related to the closing of a transaction out of any earnest money or trust funds that they are holding. So it's a little bit different, and they added that in. And also under the lease for residential property, which is GAR F913, they did talk about if there is early termination by the landlord, that the landlord does not owe the tenant an early termination fee. Now, let me talk a little bit about the buyer brokerage agreement and the new special stipulation that GAR has added for that. Well, before I get to that, there is another new special stipulation that GAR has added and in the mid-year review, and that has to do with just a contingency for receiving a condominium questionnaire. That is brand new special stipulation 528, contingency for receiving condominium questionnaire. And it basically says if the property is a condominium unit and if the buyer is obtaining a loan to purchase the property, This agreement shall be contingent upon the condominium in which the unit is located being eligible for financing and approved by the buyer's lender. If the buyer obtains written notice from the buyer's lender indicating that it is declining the buyer's loan application because of the condo is located is ineligible for financing, or the buyer's lender is unable to determine whether it's eligible for financing because of the HOA or management company will not provide sufficient information that the lender needs to make this determination, then the buyer may terminate the contract by giving notice to the seller. There is a time frame in there, and the buyer will their earnest money is protected. So there's been another special stipulation in there about the contract being contingent upon a condo being FHA or VA approved. But they've added this new one with a little bit more verbiage because a lot of lenders are having some difficulty trying to make that determination from a condo HOA or management company. Now, let me tell you about the buyer brokerage agreement. Save the best for last. Under the section where it talks about the buyer's commission obligation in purchasing real property, the buyer's brokerage agreement is GAR F110, and basically what it states is there is a lot of new verbiage about this. Again, the whole commission section was changed in January. And it became a buyer obligation to pay commission rather than an option. So under the explanatory paragraph B4A, there is a bunch of new verbiage under the commission section, under buyer's commission obligation in purchasing real property. And it states, nothing herein shall prevent a broker from being paid a commission in excess of the commission reflected herein, or from being paid a bonus, if the same is offered by the seller or seller's broker. Buyer agrees that any commission to be paid by the buyer shall be shown on the settlement statement and collected by the closing attorney as a precondition to buyer closing on the purchase of real property, so long as the same is permitted by the buyer's mortgage lender, if any. Buyer and buyer's broker agreed that the closing attorney may rely on this provision to collect and disperse any commission to be paid by the buyer. So again, there is just the verbiage that it must be disclosed, and the closing attorney can disperse it based on that. The limit on the broker's liability is the same. Now, here's the big one y'all are waiting for. A new special stipulation by GAR. And then I'm going to share with you another special stipulation that you also may find useful. So again, this has to do with the buyer brokerage agreement. And so in the buyer brokerage agreement, under paragraph A4, where it talks about commission, it says the buyer agrees to pay the broker commission set forth below at the closing of a contract and entered into during the term of this agreement, minus any commission paid to the broker by either the seller's broker or the seller. And then there's a fill in the blank for either a certain percentage of the sale price or a flat fee. Well, a lot of agents and brokers were saying, well, what if I put in a percentage or a flat fee amount here, and then with a particular property that a buyer ends up purchasing, the broker agrees to accept the co-op commission from the seller's broker as payment in full, and they don't want to charge the buyer the additional amount that was agreed upon in the buyer's brokerage agreement. And again, you don't really want to put zero in there, because then if a buyer defaults, you've got nothing to pursue the buyer after. And there's a lot of information tied up in that lawsuit, where the general consensus at this point, even though that lawsuit hasn't been settled, is not to put in 0% or a flat fee of 0, because you buyer's agents and buyer's brokers, y'all are performing a valuable real estate service, and you do not work for free. But regardless, it became an issue in practice as to how do we make a buyer feel comfortable? How does a broker agree to not do that? So let me read you what GAR came up with for their mid-year review, and I will tell you what we shared in our brokerage with our agents back in January, how to handle this. Please, if you are not with Maximum One, I suggest you run any and all special stipulations or agreements by your broker, but feel free to use this. But let me first share with you the special stipulation that GAR has added. So they have added, it is brand new, special stipulation 110, no commission owed by the buyer. And it states, notwithstanding any, this is going to be a special stipulation that you're going to use actually in your buyer brokerage agreement, not a special stip to the contract, but a special stipulation in the buyer brokerage agreement. And you're going to state, notwithstanding any provision to the contrary contained in this agreement, i.e. the buyer brokerage agreement, brokers shall not look for the buyer to pay any portion of the broker's commission pursuant to the exclusive buyer brokerage engagement agreement. I guess you could put it in the purchase and sale agreement also, but so here's my idea or stipulation that I ask you to consider. This is a blanket stipulation that the broker is not going to look to the buyer for any commission. And again, you would either use that, if you're using that as a special stipulation in a buyer brokerage agreement, then you're not expecting, it's the same thing as putting zero. If you are using that in a purchase and sale agreement, then that's in the purchase and sale agreement, but you still have that buyer brokerage agreement. But anyway, just want to let you know that's out there. Let me share with you another special stipulation that you might want to consider. So in the purchase and sale agreement, in the buyer brokerage agreement, you're going to fill out a dollar amount or a percent of the sale price that the buyer agrees to pay for your good and valuable services at the closing of a transaction. And it does state that that's the total amount minus whatever compensation comes from the seller or the seller's broker. So perhaps you might want to consider that you put that and leave that in the buyer brokerage agreement. Then once the buyer finds a property and goes under contract with a property, and you see on a transaction by transaction basis on this particular property, you as the buyer's broker determine what compensation commission you are getting paid from the listing broker or seller, then you can go back and amend your buyer's brokerage agreement. You can fill out the instruction to closing attorney based on that compensation, and you would go back and write an amendment to your buyer brokerage agreement that states, at the closing of whatever the property address is. So at the closing of 123 Lucky Street, buyer to pay, name of your brokerage, $0, as the brokerage will accept the commission of blank, blank percent of the sale price solely from the listing broker. So let me read that without my interruptions. At the closing of 123 Lucky Street, broker to pay ABC Realty $0, as the brokerage will accept commission of blank percent of the sale price solely from the listing broker. So again, the difference is that puts it on a case-by-case situation rather than a blanket stipulation. I guess GAR stipulation, if you put that in the purchase and sale agreement, achieves the same thing because that's in the purchase and sale agreement to a particular property. But that, my verbiage that I just gave you, that would be verbiage too as an amendment to a buyer brokerage agreement, and just a couple of options for you to consider. So that's it. What do y'all think? Not a lot of revisions, but a couple ones, again, based on kind of what's going on in our market right now. Thank you guys so much for watching. Hope this contract tip helped you out. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.